You can't think of any mechanism to make it in the interest of neither party. You can always decide which party's interest it's going to be by who prepays, basically. All right? Whatever the pattern of gains and losses during the life of the contract running may be, you can always shift it by saying the guy who we're afraid will breach is going to deposit $10,000 at the beginning of this process. He gets it back at the end. That reduces his incentive to breach by $10,000. Suppose, however, that you can't find a way of making it in the interest of neither parties to breach. In that case, what you do is to ask which of the two parties is the one most constrained by reputational enforcement. Which is the one who will most suffer if it becomes known that he's breached a contract. Put the risk on him, because he's the one who has the greatest incentive to keep his contract, even if in the short run it's an interest not to. If neither of them has any reputational incentive, see if you can find somebody else who does, who's willing to guarantee the contract, so that we can say, all right, both you and I are known rogues, we're not going to deal with each other again, no one would ever trust us anyway, but he is an honest man. So I will deposit $10,000 with him, you will deposit $10,000 with him, and he will turn all of the money over to whichever of us was the victim of breach by the other. And as long as he has a reputation, we can then leverage his reputation in order to enforce our contract. So that sort of is a brief sketch of the kinds of things you would want to think about when designing a contract in such a way, either where you can't enforce it. If you think about contracts in international dealings, it's really hard to enforce a contract against a government, for example. So either where you can't enforce it, or where you simply don't want to have to enforce it because litigation is expensive, this describes some of the ways of doing it. All right, let me now go on to what's, in a sense, I suppose, the more radical part of the talk, which is the discussion of how you have an actual legal system without a state. And the non-radical part, which happens all the time, is arbitration agreements. That there are groups like the American Arbitration Association, the Diamond Dealers Association, lots and lots of industries have private arbitration mechanisms. There's a famous old article on the diamond industry where, for various reasons, people wanted to stay out of courts because there was a lot of proprietary information running around, and they set up mechanisms for private arbitration where essentially the enforcement is that if you don't go along with the arbitrator's award, you're no longer in the industry because your photograph has just been posted in every exchange in the world as somebody who basically broke his agreement to accept arbitration by the Diamond Dealers Exchange. So any such system has its own law. It's got its own rules as to how it rules of evidence, rules of procedure, how it's going to arbitrate disputes. But let me go on a little further. I don't know if any of you have read a very interesting book by Robert Ellickson, who's a law professor at Yale, called Order Without Law. But the book describes a private legal system currently in operation about 2 hours from where I live. It's in Shasta County, which is a rural county in California. And Ellickson originally looked at it because he was investigating a prediction made by Ronald Coase in a very famous essay. And it turned out, when he looked at it, that the prediction was correct, but for a reason having nothing to do with Coase's argument. The prediction was that how ranchers and farmers acted with regard to the problem of cattle straying and damaging crops wouldn't depend on who was liable when it happened, on whether the rancher was responsible to fence his cattle in or the farmer to fence the cattle out. And it turned out that Shasta County, for reasons of historical accident, is a patchwork of open and closed range, of places with one legal rule and with the other legal rule. So Ellickson went to see, and sure enough, ranchers and farmers behaved the same way in both places. But the reason they do that is that with regard to trespassing cattle, the law of the state of California does not run in Shasta County. Why does it not run in Shasta County? Because Shasta County has norms of neighborly behavior. This is a relatively rural, relatively static society. People have lived there for a long time. And everybody knows how neighbors are supposed to behave to neighbors. And one of the strongest norms of neighborly behavior is that neighbors don't sue neighbors. And if everybody knows that going to court is going to cost you more than it's worth because everybody will regard you as an unreliable neighbor thereafter, you don't go to court. There are, however, mechanisms to enforce the rules that do exist. There are understandings about when your cattle trespass on my field and eat my tomatoes, what you're supposed to do and what I'm supposed to do. And there are rules for enforcing those. In particular, if you don't behave as you should, if you don't apologize and help me replant my tomatoes and do the other appropriate things, by about the third time your cattle trespass, I am entitled, instead of calling you up, to drive the cattle off my property, drive them 3 or 4 miles in the direction opposite of where you are, and then go home. And leave it to you to try to find your strayed cattle, and everybody will recognize that as a legitimate punishment, even though it's not a legal punishment. I have no legal right to drive your cattle around. Your neighbors will realize that you're the good guy and he's the bad guy. So that's an interesting case, and norms in general provide a nice example of law enforcement outside the law, and of law outside the state, in effect. My earlier case of the parking places in Chicago is really a case of privately enforced norms. But let me now go on to the full-scale version, because this was the subject of my first book, as it happens, published about 1972, so a long, long time ago, back before most of you were born. But it's still, I think, I hope, being read, and it's available on my website for free downloads, the PDF, if you don't want to try to buy a hard copy, which is hard to do because it's, in fact, out of print, although the publisher hasn't admitted it yet, so it's very expensive on Amazon. I'm getting my copyright back. That's why I care about these things. I'm going to do another edition. But in any case, that book, one section of it, part 3, discussed what a society would look like in which there was private property and was no government. And it was a theoretical sketch. And it goes as follows. You have private firms that are in the business of protecting their customers' rights. So you pay some annual fee to a private firm, just as you do an insurance company, say, today, and that company agrees that they will protect you from burglars and murderers, and if you have disputes with somebody, they will arrange to settle disputes. And the obvious problem with this system, which everybody who hears about it immediately jumps on, is, but what happens when I think you've stolen something from me, and my private firm goes to you and demands it back, and you reply, oh, but I have a private firm protecting my rights, and they won't let you take it back. And various people from Ayn Rand on say, obviously, this will result in violent conflict and terrible system and all that. But the response, of course, is that violence is very expensive. So a much more sensible solution is that the two rights enforcement firms make a deal. They say, look, if there is a conflict between your customer and my customer, instead of fighting each other, which is going to be very unpleasant, might get somebody killed, we will agree to let this private judge over here, this private court system, arbitrate our dispute, and both of us will agree to go along with that arbitration. Ah, you will say, but since we have no government, how will that contract be enforced? This problem we've already solved, because these two agencies are going to be dealing with each other for a long period of time. The situation will occur again and again, so we're back with the discipline of constant dealings. Each of the private rights enforcement agencies knows that if it reneges on the agreement when its customer loses, the other one will refuse to arbitrate next time. The result will be that when there are conflicts between their customers, somebody might get hurt, or they can't protect against each other's customers or whatever, and the result is they will lose their customers to other firms that, being sensible people, keep their arbitration agreements and thus maintain peaceful and inexpensive arrangements among themselves. So I've now just described a very brief sketch framework for a society of law without government, in which the law is privately produced by the private courts. In principle, every pair of agencies might have different laws between them, because each pair of agencies is agreeing on the private court that will arbitrate their dispute. There's going to be a certain amount of market pressure for uniformity. It's easier to run your life if the legal rule that applies doesn't depend on who your dispute is with, so there'll be some tendency for the private courts to adopt similar legal rules. But it's not. There's no requirement. There's no overarching authority making them do so. And one of the attractive features of this system, aside from the fact that there is no government that claims special rights that other people don't have, one of the attractive features is that the law is being generated on the market. That one of the things economics tells us is that governments are very bad at producing goods and services for reasons which we could go into, but which I think are fairly well understood. And yet a lot of people take it for granted that even though governments are incompetent to run agriculture or run auto factories. They're perfectly competent to manage the perfectly trivial job of writing a legal system. And hopefully most of you are far enough through your